this on? Can our reporters hear? Can you all hear in the room? So, ladies and gentlemen, welcome. I'm Daniel Bethlehem, presiding in these proceedings. I'll invite everyone, the tribunal and the parties, to introduce themselves in just a moment. Let me just begin with one or two as a pre-housekeeping announcements so that we've got everything in order. I'd just like to note that the hearing is being webcast. So both audio and video are on at the moment, and they will remain on until we are told that they are off. So just a reminder that everything is being picked up and being broadcast. Let me remind claimants that one of your witnesses is sequestered, and that you should take all necessary steps, as I imagine you've done, but to remind him that he should not view the proceedings or discuss the proceedings or his testimony in advance of his testimony tomorrow. I note, just as a pre-housekeeping matter, that the tribunal has not been notified of any protected information that requires protection from disclosure in accordance with paragraph 23.6 of procedural order number 1. If that is incorrect, please make sure that you draw that to the attention of the tribunal secretary, Juliana Kane, as soon as possible. We don't want to inadvertently stumble into issues of protected information in the course of the proceedings. I also note, and after this I'll turn to the introductions, that these proceedings are being simultaneously translated, simultaneously interpreted. So please do have regard to the interpreters and speak at a pace that they can manage. They will draw our attention to anyone who is speaking too fast or, for that matter, too slowly, just to ensure that everything is being managed properly. I think with that, I would like to go through the introductions and first of all to call on my colleagues to introduce themselves. Mark Cantor.
Thank you. I'm Mark Cantor from Washington, D.C. I do have an apology to make. I will be chewing gum throughout the entirety of these proceedings or using throat lozenges. I've unfortunately developed a bit of a swallowing problem, and the gum mitigates that problem. It does not mean I'm being disrespectful to any of you. It also does not mean I've reverted to being a 16-year-old.
Raul Vinuesa.
Good morning, everyone. I'm Raul Vinuesa from Argentina.
And our tribunal secretary, Juliana Kane.
Hello, I'm Juliana Kane. Other 2 points on this, you have in channel 1 the English translation and channel 2 on this, the Spanish one. Remember to bring to me or to the interpreter any presentation or document that you want to have in the record so they can be facilitated, and to speak to the microphone and to switch off the microphone when you're off. Thank you.
Mr. Copa, would you like to introduce the claimants?
Yes, thank you, Mr. President, members of the tribunal. My name is Jeff Coper, and I'm counsel for the claimants with other members of the team who I'll introduce in a moment. I did want to say that it's a particular honor to complete this proceeding in this year, which is the 50th anniversary of the UNCT Convention, and many of us gathered earlier in this year to honor that anniversary. It's a particular honor, though, to be able to complete an investor-state dispute this year. My clients are present either in person with their families or by webcast, and I wanted to thank you, members of the tribunal, for making that available to them. I wanted as well simply to note that this overall exercise we're engaged in from the perspective of the claimants is enhanced by its public transparency and the availability of members of the public to see the webcast, and so we thank you for that. And in advance, the claimants would like to thank you for your service. I believe in the earlier convention someone commented on investor states bringing the rule of law to the globalization phenomena and being a civilization-making exercise. Those are challenging terms for the professional community to fulfill. We'll do our best this week to merit that challenging note, and we note and respect the fact that they're also uncomfortable proceedings for states such as Costa Rica, and we will try in our submissions and through our evidence to respect Costa Rica and its efforts to deal not only with these claims, but the very many challenges that every state confronts in these times. So with that, Mr. President, I've already indicated myself. To my immediate right is Tina Cicchetti, who is a partner in the firm of Faskins with me. And to her immediate right is Dr. Todd Weiler, who is well known in this field. And to his right is an associate of our office, Alexandra Mitratodis. And to her right is Ms. Tracy Cohen, who is a partner in office. And at the end of the, if I may say, the battery of Claimants Counsel is Mr. Vianney Saborio. And let me use that moment to apologize for the rest of the week for my pronunciation of anything that looks or sounds Spanish. So I hope that's a generic enough apology that I don't have to repeat it too often in the coming days. Let me just say, while I'm doing introductions so the members of the tribunal know you're going to be hearing from more counsel than me this week, and in general, so that you have in your minds, Ms. Cohen is going to be taking damages. You're going to be hearing largely from Dr. Weiler with respect to international law and investor state technical issues, and you'll be hearing primarily from me with respect to the factual issues, and I will take the lead generally. So hopefully, as more of an extended introduction than you perhaps anticipated, but that's Claimants Counsel.
Are there any other members of your as it were, attending representation that you would like to introduce?
I think I'll just generally note the attendance of the claimants and their members of the family. I won't go down given the number to identify them for present purposes.
Mr. Alexandrov.
Mr. President, I will introduce the members of the team, including the party representatives and the client, but we would like to put a name to the face. Could we ask our colleague to introduce everybody in the room, please?
People are going to have to move out of their way. So the person immediately to the right of VNA is Mr. Brett Berkowitz, and to his right is Mr. Bob Reddy, and I believe behind him is Mr. Ron Kofer, and behind him is Mr. Bob Spence, and to the right of Mr. Bob Spence is his wife, Marcia, and the final individual is Joshua Kofer, the son of Ron Kofer.
Thank you.
Thank you, Mr. President. I will introduce respondent side in the order in which they sit at the table for ease of reference. Jennifer Howard McCandles of Sidley Austin, Maria Carolina Duran of Sidley Austin, I'm Stanimir Alexandrov of Sidley Austin, Courtney Hikawa of Sidley Austin, and then we have the representatives of the government of Costa Rica, Adriana Gonzalez, Karima Sauma, Andrea Sumbado, Georgina Chavez, Julio Jurado, Rotni Piedra, and then we have Andrew Preston, who's actually not present at the moment, but he was here a moment ago from Navigant Consulting.
Thank you very much. Let me invite the non-disputing parties who's sitting so far at the back of the room that I require a telescope to see you, but just to introduce yourselves. For El Salvador. Please do.
Good morning, Mr. President, members of the tribunal. My name is Luis Parada, and with my colleague Erin Argueta, we are representing El Salvador as a non-disputing party in this arbitration. Thank you.
Thank you very much. And for the United States as well.
Good morning, Mr. President and members of the tribunal. I'm Jeremy Sharp from the Office of the Legal Advisor at the Department of State. I'm here with my colleague Nicole Thornton, also from the Legal Advisor's Office. It's a pleasure to be here. Thank you.
Thank you very much. And I simply note for all of our attention in the room that we've got two written submissions from non-disputing parties from El Salvador and from the United States. El Salvador has already indicated that it wishes to make an oral submission, and the tribunal has agreed that that should come tomorrow morning. To the United States, I'd invite you by the close of play today to indicate to us whether you would also like to make an oral submission, as you'd be entitled to do so, and that would then follow tomorrow morning as well.
Thank you very much.
Thank you. A number of other housekeeping matters before we proceed to the substance. Publication of pleadings on the ICSID website. I think the tribunal has addressed this to the parties in correspondence. We were hoping that we would get a response from the parties at the start of these proceedings, whether you have any objections or not. I don't invite you to make any objections at this point, but perhaps you could signal that to the tribunal secretary during the course of the break. The tribunal would like to facilitate transparency insofar as the parties do not have any objection. We note that Costa Rica has already published the pleadings on the government website, although not the annexes. At the moment, I think, Juliana, you can tell me whether there is a link to the Costa Rican website on the ICSID. Not yet. So there is no indication of pleadings on the ICSID website, but subject to the views of the parties, we would like to do so. So if you could inform the tribunal secretary in due course, if you're content with that.
Well, I don't need a time. That's satisfactory to the claimant.
Mr. President, no objection on behalf of Costa Rica either.
And let me just be sure that I understand that relates to annexes, all the other submissions that the parties have put in.
Yes.
Thank you. Well, ICSID will turn to that as quickly as possible then. Thank you very much. Did you have, sorry, Mr.
No,
Alexander.
I was just going to confirm. And by the way, when you say annexes, we refer to them as exhibits. If that's what you mean, Mr. President, we have no objection to publishing the record of this proceeding.
Yes, I was being generic. I think there are some appendices, there are some annexes, there's quite a lot of documentation that that we see on the wall over there and that we've all got on our systems. But if you contend for all of that to be put on the website.
No objection to publishing anything that's in the record.
Thank you very much indeed. Let me, just for good housekeeping reasons, address the schedule of the hearing. Today, as we know from the tribunal's correspondence to the parties, we will have the claimants opening this morning. We will then move to the respondents opening this afternoon. Mr. Coper, I would invite you, when you stand up, just to give us an indication of whether you intend to reserve a period of time for claimants' reply on jurisdiction at the end of the day, simply for good housekeeping purposes, but that we'd already anticipated. Tomorrow, we will start with El Salvador as a non-disputing party with El Salvador's oral submissions. We await to hear from the United States whether it wishes the same facility. I should say at this stage that the tribunal anticipates that we will have questions to put to the parties in the light of your opening this morning and this afternoon. We propose to raise some of those questions, or the questions that occur to us of a general nature, after the non-disputing parties have made any oral submissions that they propose to do so tomorrow, and then to give you the opportunity, either or both, to give some immediate responses, if you'd like to give some immediate responses, or to save up those questions and to give responses as part of your closing. But we thought that it would be useful for you to have questions as early as possible. We will then, after those questions, move to the claimants' witnesses of fact. Subject to issues of timing, on Wednesday we will then move on to the respondents' witnesses of fact. Thursday is given over to the expert evidence of both the claimants and the respondents, and then on Friday we will have closing submissions. I imagine that there will be little issues of time management that we will have to address as we go along. We know that both parties have been given an equality of time, 12 hours apiece, to use as you think appropriate, subject to the guidance that we've given following consultation with you, that we have a 2.5-hour period in opening, a 2-hour period in response. Of course, any time that you use in response to questions from the tribunal is our time rather than your time. We propose to break about halfway through the morning sessions and the afternoon sessions. So I would invite counsel for the claimants and the respondents to indicate when would be a convenient time during those submissions to take a break. I'd like to remind you that any procedural motions, applications, objections that you have that you can anticipate, please make them in a timely fashion. We'll give you an opportunity at the end of the day if there's anything that you anticipate that you'd like to raise, notably in respect of the proceedings the following day. It would be helpful to have those from you as early as possible. Subject to anything that our tribunal secretary has to say, I think we will be getting transcripts at the end of the day. The procedural order addresses the time period within which you should be coming back with any corrections. I'd like to, just for good order, invite the parties to meet with the tribunal secretary at the end of every day, just to ensure that there are no lingering difficulties over time allocation. Last point, simply about questions from the tribunal. I think we have concluded that we would like to be in a position to put to both sides immediately questions that seem to us to require clarification, immediate clarification, so that we don't have any lingering uncertainty just in terms of our own understanding. But in terms of larger questions, we propose to save those up to the end of the 2 opening submissions, and then, as I suggested, to put those to you jointly, leaving you with the option of whether to reply then and there or to do so as part of your closing. I think that's everything in terms of the formalities, unless either side has anything that they would like to raise with us. Mr. Coper, anything just in terms of the formalities that you'd like to raise? Okay.
I just said I'd like to start my opening, and
Okay.
nothing further by way of housekeeping.
Thank you. Mr. Alexandrov?
Mr. President, 2 points. Dr. Weiler signaled to me that our experts from Navigant are now into the room, and I haven't introduced them, so I'd like to introduce Mr. Kazmarek, Brent Kazmarek, and Mr. Andrew Preston, who are sitting at the end of the table. My second point is we have a pending application, and because opposing counsel suggested that they can start with the opening now, I wondered whether you wanted to address that application before.
Thank you, Mr. Alexandrov. That's my omission. I intended to address it. It was simply to say that we noted your application of last night. We saw the claimant's response objection to that application. We will come back to you during the lunch break with our decision. Thank you. I think then, without more ado, Mr. Coper, we turn to you to kick us off.
Thank you, Mr. President. Just by way of time allocation and to let you know how we've allocated our time, I will reserve 30 minutes for reply on jurisdiction alone that will take place later in the day, and Dr. Weiler will address the question of jurisdiction. And for the purpose, as the respondents bear the burden on both jurisdiction and the time bar within the treaty, he'll be addressing both in reply. I will also say, in respect of questions, that in general, of course, there are questions which beg an immediate answer, and if I can give you an immediate answer, I will. If I defer to later, it'll probably be as a consequence of knowing that my team will want me to make sure that I got it entirely right. So don't take from my deferral that we don't have an answer or that I don't have an answer, but just given the allocation of responsibilities within the team I indicated earlier, we'll be fairly cautious in permitting me to answer a question immediately. So thank you very much. We have a PowerPoint, and pursuant to the procedural order, I have a PowerPoint I'd like to use for the purposes of our opening. We have also provided a PowerPoint with the pinpoint references to the extent that they refer to the evidence or law references. The visual PowerPoint doesn't have those, so we'll file with the Secretary the references so the tribunal will have those, and my friend will have a copy of those. And I should also say you invited me to stand, which is my normal posture in proceedings, but it's not convenient here, and I won't go to the center stage because my team wouldn't allow me to be that far away from them, I think. So, and I believe things are now being, the opening is now being handed out. I'll just wait a moment until I get the green light to proceed.
is an off-the-record comment. Gonzalo Flores came to me just a moment ago, very proudly showing an iPhone with the broadcast working perfectly. So.
Well, that's intimidating.
Okay. If we could go to the introductory slide then. Thank you, Mr. President. The first slide deals with, at the most general level, the claimant's case. We, by way of opening, submit to you that the facts which are already in the record and that you will hear by way of evidence this week will establish that the respondent has engaged in a consistent and ongoing refusal to honor its promise to foreign investors that if their property is taken, the fair market value of their property will be paid without delay. And I'll deal with this later, but in a case like this, it is important to define what is at stake. And let me say that we do not, of course, contest the right of Costa Rica to expropriate the claimant's properties. We do call upon the state of Costa Rica to honor its promise as to how it will take properties and how and when it will compensate for them, those promises being embodied in the treaty upon which the claimants rely and in customary international law. The second point of general interest from a council point of view is that in our submission, and we'll come back to this in our closing submissions, this is not a case involving novel questions of treaty law or novel questions of international law. The claimant's case calls upon the core guarantees of international law, and in our submission you will not need to make any novel conclusions of law in order to find in favor of the claimants. The next point is a general question about the facts, and I'm going to deal with the facts in general, but I've tried to characterize them in a fair fashion, in that the general state of the facts here is that the claimants as foreign owners of property in Costa Rica adjacent to this particular park, at the end of this sorry history, which I'll deal with in some detail later this morning, have essentially become the victims of an internal debate about whether to allow responsible development in a sensitive area. And it's helpful for me to expand a little bit on that and to say another matter which the claimants do not contest is the need for responsible development in environmentally sensitive areas. None of the claimants ever anticipated, expected, or wanted irresponsible development. Each of them saw the proximity of the marine park as an asset to the value and enjoyment of their property, both for themselves, their families, and purchasers of the development that was in mind. And so effectively what happened, and you'll see this in greater detail, is that within Costa Rica there was a spirited debate which has a great deal of detail about it, which is why we're taking 5 days in part this week. But that debate was, ought you to allow responsible development adjacent to the park? Ought you to define the parameters of the park so as to exclude the possibility of responsible development? The outcome of that has been concluded, but we say, in essence, that the overall history is that it was conducted with a view to delaying and avoiding the liability to compensate for the properties that were affected by the outcome of that debate. And in fact, that leads to my next general point, which is, from a practical point of view, the outcome for my clients was that their properties became valueless. But the outcome of the debate, we say on a fair reading of the record, landed the government of Costa Rica with an unwelcome obligation to compensate our clients. And like many governments confronted with an unwelcome fiscal obligation, they have followed a variety of tactics and strategies to avoid, minimize, delay, and defer the obligation to compensate. And we say those are relevant both under the treaty and under international law. And so where are we now? For the most part, there are a few properties which have been transferred, very few, but for most of the properties at issue, the claimants stand in possession of zombie titles of property. And we've had a debate about how to characterize this, and this may not be part of the culture of any of the members of the tribunal, but in North America, most 16-year-olds are obsessed by zombies. So I'm speaking to Mr. Cantor now in this respect. And I think the analogy with zombies is appropriate. You know, the zombie is the half-dead, suffering individual who isn't dead yet, but to all appearances is useless. And that's exactly the titles that our clients still have. They're half-dead. They haven't been killed because property's not been transferred to the state. They haven't been compensated for the most part, and where they've been compensated for, they haven't been adequately compensated for. But they're still around, so they still have to deal with the taxing authorities. They still have to deal with the fact that they still own these properties. So we stand today in an entirely unsatisfactory stage. And indeed, and I'm going to summarize my friend's position, but my friend's position in general appears to me to be either that these claims are out of date or premature, that the titles we all have can't be the subject of a proceeding because you have to wait, and the titles which we don't have and which have effectively been gone are out of time, either by reason of the treaty period or limitation period. We say neither is true, and that the proper resolution is to bring an end to their status as zombie titles, to conclude this unfortunate history by an appropriate declaration of compensation, and of course, as the respondent has requested and properly requires, a transfer of the title to Costa Rica to resolve the final issue. At that point, the expropriation process will be complete. Finally, by way of introduction, the claimants, of course, are concerned that much of their experience with Costa Rica has been involved in the various government agencies responsible for compensation using a variety of techniques to minimize and defer compensation. In this particular case, I brought to your attention from the beginning the unique quality of these properties, because a great deal was at stake in the development of these properties because they were unique, free title, beachfront properties on one of the most beautiful locations in the world. And that is what undergirds the claims and the quantum of the claims which have been claimed in these proceedings. So if we could go to the next slide, and I promise you that the next 222 slides won't take me as long as the first slide. How did the claimants come here? Well, let me summarize the situation for the Kofers, Mr. Holston and Bob Spence. And I won't, at this point, ask you to make any notes because I'm going to draw a very general picture, but in general, in 2003, Ron and Brenda Kofer, who were then in their mid-50s, were making plans for their retirement. And they had been frequent visitors to Costa Rica, and they decided to spend part of a year in Costa Rica. If I can pause there, they are precisely the type of people Costa Rica wants to attract. They are well off, well-to-do, successful individuals who want to enjoy the amenities of Costa Rica and to make it their home for part of the year. That was their goal. They began to investigate properties to build their dream retirement home. They purchased a home in Playa Conchal in which to live temporarily while they were doing that. And they fell in love with Playa Ventanas, which is the northern portion of the property at issue in this case, and which of course had, as you know, a secluded white beach, which at that point only had a few homes on it. Those lots are accessible by a public road. It has an estuary on the opposite side, and they regarded all of that as desirable, including the fact that there was a park adjacent to it. And they were told, as you'll see from their witness statement, that the park went out to the sea. It was a marine park that went out to the sea. They also, by the way, when they were visiting the properties, were joined by their friend Bob Spence, who was another claimant in these proceedings, and he had a similar goal in mind, and he ultimately, similarly, is a well-to-do individual who is very successful in business in the United States. He wanted to build a dream home, but he also saw the potential for an investment, a development, and profit selling to similar people who had also been successful would also see the potential for building dream homes and would contribute to the general, frankly, huge success of Costa Rica in marketing itself as a safe, attractive, and enjoyable location for international people of means to come and spend part of their year. So we'll get back later in that, but those, both the Kofers and Mr. Spence purchased properties in 2003 and following. And just to deal in general, they both proceeded to take steps to see what they could build. They hired, Mr. Kofer hired an architect to draw up plans, to have an environmental impact statement prepared, and initially things went well until, of course, the very long delays, which we will deal with in detail later, commenced. Mr. Reddy is the representative for Spence, the corporate entity of Spence involved, and Mr. Reddy has supplied witness statements, but he was very involved in locating the investments which were made, which form part of the claims here for the corporate defendant. And as you'll see from the Mr. Reddy's witness statements, he was aware of the 1991 park decree. That wasn't a mystery, as well as the 1995 park law, which described the park boundaries as being seaward from the mean high tide. And some of the properties that were purchased were, of course, within the landward section of the high tide, which you'll see, as you know from the pleadings, ended up becoming the point of dispute. Just to draw to your attention at this time, this was a place of great potential, and the debate in part was how should that potential be realized. I'm going to skip a little bit to deal with Mr. Berkowitz's story, because I think that bears on that. He had a history with Costa Rica. He was, earlier in his life, he was a surfer. He had suffered an injury as a chiropractor, not allowing him to continue with his profession, and so he decided to spend most of his time in Costa Rica, and in order to earn a living, he decided to be involved in building and residential development. He had seen as a very attractive purchase the parcels, many which are an issue in this proceeding, because a large subdivision and development had been proposed on those parcels and had been controversial. And the opportunity that he saw, which is explained in his witness statement, was of a low-density, high-end, selling to wealthy individuals development, which would make use of the attractiveness of the being adjacent to the park, make use of the fact that it was not a high-density development as has occurred elsewhere in the country, and to take advantage of the general huge rise in the value of land and in the economic tourist potential of the northern part of Costa Rica, which arose in part because of the development of the airport in the north in Liberia. He had a dream for a dream home as well, and he had an architect draw plans, and those plans included the types of things which we have filed as evidence are appropriate for properties which are adjacent to a turtle nesting site. They include architectural features to reduce the lights onto the beach. They include voluntary setbacks from the property. They include fascia to block the shedding of lights. And I'll just pause here, and the reason that we filed Mr. Rusenko's witness statement in large part was to indicate that the responsible development that is spoken of by the claimants here is not a pipe dream, and it's not an effort to, by indirection, have development which harms the nesting sites of the turtles. Rather, it actually represents the best thinking of how human beings can coexist with nesting turtles. And as much as we're all concerned with the environment, we're also of necessity concerned with the economy, as is Costa Rica, as were the claimants. And their goal was to reconcile their economic dreams and aspirations, not only for the construction of highly valuable retirement homes for themselves, but also for resale of properties to others with similar dreams, without contradicting the conservation goals of the marine park. Now, with respect, I think I'll stop there in terms of the particulars, but of course Mr. Gramillion is another claimant who purchased property and had a similar experience to Mr. Spence, the Kofers, Mr. Holston, Mr. Berkowitz, and all of them experienced, and it's without question in these proceedings, a suspension of any right to develop and make use of their property as the years passed. So that is intended to give you a little bit, in a large international proceeding, a perspective of the individuals involved, and the fact that this case does not involve an international company. It doesn't involve an entity that is seeking to contradict the public policy of a state or to influence public policy in any way other than to try to reconcile the stated goals of conservation and the desire to have responsible development alongside. So if we could then go, if you could go back, Alexandra. So just, this is to orient you. This, of course, the Guanacaste region is in the northwest of the country, and this is within Guanacaste, and you'll see the Liberia, which is the location of the relatively new airport, which was a key feature to opening the north of the country to tourism. If you go to the claimant's lot slide, which is the next one, this is really just to orient you north to south. Ventanas, of course, is in the north. Playa Grande is in the south part of that map, and you'll see the lots in issue identified by letters and numbers alongside. If you go next to some pictures, no PowerPoint is complete without pictures. I have to say that I militated for audio at this point, to have the sound of beach waves and birds play at this point. I was overruled. Apparently I was the only person who thought that would be effective, but I was overruled, but I'm still speaking. So if you could just imagine the waves and the birds as you look at this slide, there is no question that this is one of the most beautiful and accessible areas for tourism in the world, and that Costa Rica is rightly proud of its natural resources. The next slide.
We note that the parties agreed that there should not be a site visit on the part of the tribunal.
Reluctantly. The next slide is Playa Grande, similarly a beautiful white beach. And from a legal perspective, as is noted in the materials and is undisputed, the properties at issue are unusual in that they represent free title land on a beach in Costa Rica. If we then go next, I think I've commented on these features. The next slide, which is just, you'll see that dealing with money for a moment, foreign real estate investment, you'll see that Santa Cruz, which is the county within which we're dealing with, was fortunate to receive a substantial amount of foreign real estate investment in 2004-2007. Let me just pause to say, because during one of our preliminary hearings I made this point, which is that from the claimant's perspective, they're calling on the promise of the state of Costa Rica to honor foreign investment and to provide the minimum foreign guarantees for foreign investment, which have been the subject matter of international law for a very long time and are the subject matter of the treaty we rely upon in these proceedings. But that promise is actually simply arising from the success of the offer of Costa Rica to open itself to foreign investment. And that offer was acted upon by the claimants and by many, many other people, and has been responsible for a good deal of the success that Costa Rica has enjoyed in the last number of years. And it is simply that promises come with a price. And that if people are injured as a result of acting on that price by your actions, then compensation is necessarily required. What we're engaged in here is that my clients, being foreign investors, do not have to content themselves with the domestic legal order, the benefits and the disadvantages of that. We fundamentally can rely upon the rule of law to have their dispute decided according to law before an international tribunal because of the existence of the treaty. The next slide is tourism in Guanacaste. I won't deal with that, but of course there has been a dramatic and productive and important increase in tourism. When I was reading last night the administrative appraisals, which of course in our view understate the values consistently, one thing that they make note of is the entire shift of the Costa Rican economy from an agricultural economy to a services-based economy, which in significant part revolves around the tourists and the people who would have come and purchased these lands, and in many other parts of the country have done so. It's not the case that the failure of these claimants' desires have frustrated development generally in Costa Rica. This is a sad chapter in an otherwise very successful voyage of foreign investment and development. The next, if we could go to the leatherback turtle, as you gather from our pleadings, our fundamental position, this is actually not about the turtles. My friends have said it is about the turtles, so I didn't want to ignore the turtles in my presentation, so here are two of them. The turtles, of course, are massive, and they do require beaches to nest. They don't climb trees, and they don't go into vegetation to do so. And that's the fundamental basis of the ability to reconcile the need for nesting beaches with the ability to develop alongside them. And we'll deal with that. We've dealt with that in the evidence. And if we could go on, one of the tragedies associated with the leatherback turtle, which by the way is generally present in the Pacific, and actually I'm from northwestern Canada, and we have leatherback turtles off the coast of Vancouver Island, which have been seen. So it's a general Pacific population, and you'll see from this slide that long before the events that we're dealing with here, there's been a catastrophic decrease in the turtle population. It has not been as a consequence, we say, of the development of the type of development that our clients had contemplated. If you go to the next slide, the causes of decline include egg harvesting, and by definition, these beaches are often found in areas of poverty. Emptying a turtle nest takes a very brief period of time, and you can harvest 100 eggs for you and your family. And for poor people in poverty, that's obviously an attractive source of protein and food. But it obviously can impair an entire world population of sea turtles, and has. Long line fishing has been has had a dramatic impact on all species of sea turtles, because the long line fishing presents bait. The turtles take it, and you can characterize it as bycatch, but they're essentially killed as a consequence of the continuation of long line fishing. Some people, just to round out the thing, have cited global warming. I think that's unclear as to its role, and other people have referred to concern about development near nest sites, which is why the development has to be responsible. But there are, and you'll see from the witness statements, successful nesting sites adjacent to highly developed locations in the world. You'll see this next slide just summarizes just how dramatic the decline in turtles has been, and this is just a note of how terrible poaching or egg harvesting can be. And then that'll be the end of the turtle section of my opening. If we could then go to facts around the park. And so I will take it the members of the tribunal have read the pleadings generally, and of course you'll have time to read them more carefully. So by way of opening, I'm going to deal with it generally to try to introduce and sort of fasten in your mind some of the themes we rely upon here. In looking at the pleadings in preparation for today, it may be useful to think some of the details actually not that critical in terms of resolving case, as always. But if we start with the beginning, the park was created by decree in 1991. And when you say creation, and just to give you sort of a sense, parks are not actually fully created under Costa Rican law until the private property within the park is expropriated and paid for. That's a consequence of the general park law, consequence of the constitutional guarantee of property. And that's why you'll see in the materials, government materials and otherwise, references to proposed park or consolidation process, because the consolidation process inherently involves reconciling private property interests with a national park. And of course, that means that the fiscal consequences of building a park, if I can use the word rather than creating a park, are ever present. In some of the respondents' materials, it suggested that the fiscal problems here were not real, That seems to be a controversy between the parties. For our part, there are multiple references that make it abundant, both in terms of witness statements as well as documents, that the cost of fully creating a park and taking all of the property within the boundaries of the park was ever present in the minds of public officials. And the resolution of that was either to avoid doing that by defining the park so as to not include property that would have to be compensated, or otherwise seeking to avoid the consequences of the constitutional guarantee of property and the general requirements of the park law. The next thing is that the decree in 91, just to anchor yourself, of course, deals with a southern part of the beaches we're talking about. So it's Ventanas South. It doesn't deal with the northern part of the property, part of the beach. Now, so what you had was a decree, not a law, but a decree seeking to create a park in the southern part of the area, the Playa Grande area. Then in 1995, you had a park law. And by way of the most broad thing, part of the reason we're here is because the 1995 park law created a marine park and not a terrestrial park. By reason of a long and somewhat complicated history, it ended up being both a marine and terrestrial park by reason of the final decision of the Supreme Court of Costa Rica. For reasons I'll get into here, in our view, that is clearly wrong. But every Supreme Court of every country is entitled to be wrong. That's what we appoint them to do. But the consequence of that, of course, is that having decided that, the obligation of compensation clearly arose. So the 1995 park also expressly addressed the rights of private land within the park and protected those. And it clearly contemplated that there would be development despite the existence of the park. If I can then go down, and are we going to play the video? I see Mr. Pedro is present, and he's going to be present later. This is a video.
Estamos hablando de que los 50 metros de zona pública que se conoce comúnmente es lo que tenemos de parte terrestre y el componente de manglar. Y tenemos las 12 millas marinas. Entonces,
so if we flip over to the English translation of those remarks, and this is, you may want to make a flag here. This is a question of controversy. Mr. Pedro says his comments are taken out of context. But the comment we rely upon is, it is a marine park. When we talk about a marine park, we're referring to the more commonly known 50-meter public area. And this was in the context of an effort by many to expand the park, to ensure that the park would include a terrestrial area and not be restricted to a marine park. And I'll deal with that in detail, and we'll deal with that in detail in our closing. What you need to have in mind is that after the 1995 park, there was dissatisfaction by many with the absence of a terrestrial component to the park. And we say that it's a rewriting of history to suggest that everybody knew that the park proceeded inland. Now, if you go to the next slide, I've already indicated this. I think we can slip. Here's just another slide on the Tamarindo Refuge, and this will show you prior to 91 the protected area along the coast, which is narrow, and the estuary, which is behind. So when I say the estuary opposite, you have both a freshwater estuary and an ocean in the same area. Then if we go to the 91 decree, this just simply amplifies my description. Below you'll see under Article 1, in the very beginning of the second paragraph on the left-hand kind, from a point located in the southern end of Playa Ventanas at a distance of 125 meters as of the ordinary high tide. So the decree contemplated a terrestrial component. And if you then go on, you'll see that it says, and I have a slide later on, Article 2 says every residential development, any other type made in the zone shall be approved by the Ministry of Natural Resources, Energy and Mines. That's part of the respect for private property and development by private lands within the area. Now this Article 2 refers to Playas Carbon and Ventanas and the 75-meter zone applicable to those properties. I have a later slide which deals with the land within the decree. You'll see equally in the next slide, Article 5, that the declaration of the national park is fully valid once the state purchases the private properties existing within the delimitations. And that is a reflection of the general law and the constitutional right and protection of property I referred to earlier. And we then skip to the 1995 park law, and this has the broader boundaries, which include both Playa Grande and Ventanas, and that's clear from Article 1. Now, and here is where the historical event arises. It's our case that the legislature specifically understood that it was being requested to preserve a terrestrial component to the park, which had been the subject of the decree in 1991, and that it specifically rejected that request and that proposal. And you'll see in the legislative debates in the next slide, the motion at the bottom was to amend Article 1, where it says after 125 meters from the ordinary high tide, add into the water, or aguas adentro. And there's no doubt that those phrases, understood ordinarily, meant that what was being created in 1995 was a marine park as described by Mr. Piedra, and not a marine park with a terrestrial component. So essentially, you would have the 50-meter public zone, and you would have a 125-meter zone heading into the waters. And there was both reason and justification for that. If you go to the next slide, you'll see that in the legislative debate, it says in English, it appears to me that it meets the requirement of a law of this type to protect parks, especially it should have been marine, because that is what is customary in this case. It wasn't mentioned as being marine. When the park is defined, it talks about 125 meters, an imaginary line, and that should extend into the water. Exactly what I think this motion has clarified, present unanimously approved. So as a matter of pure history, we say there can be no doubt that there was a legislative decision as to the boundaries of the park in 1995, and that decision was to exclude the terrestrial component that later arose through the complicated proceedings culminating in a judgment of the Costa Rican Supreme Court. And a later letter from Congressman Fournier speaks about this. If you go to the next slide, it says, I recall at the time we discussed, since it was a national marine park, and I'm at the second body, created to protect the leatherback sea turtles that use the beaches, it should be strengthened. It says, furthermore, as occurred with the decree in 1991, which created the park, we were not presented with any environmental justification whatsoever for establishing an area of onshore protection measured starting from the edge of the 50-meter strip, which includes the most important part of the protected ecosystem, i.e. where they lay eggs. In that considerable strip of 50 meters that runs along more than 5 kilometers of the coastline, a beach area and a tree farm form a natural protective barriers. These elements ensure that sea turtles have a nesting area that is free from anthropogenic effects. Now, whether, and that is, if I may say, something that everybody could debate about how big the park should be. What we rely upon is the pure factual history, which is that was the legislative decision at the time. And so when we come to deal with the history of the claimants, they had every reason, both legally and factually, to believe that their lands were capable and appropriate for the developments that they had in mind, and that they would receive an appropriate governmental response to efforts to develop and sell those lands, or to develop them and enjoy them as retirement homes. Now, another, if I will say, corroborative point was the explicit effort to expand the park. And a number of people in the historical period said the 95 law is wrong. We should have actually a larger terrestrial component, a terrestrial and a large terrestrial component for the park for both general conservation reasons, the reasons you create any park. You want to have a bigger park for preserving not just for turtles, but for other reasons, and making it attractive to turtles, et cetera. If you, sorry, attractive to tourists, not turtles. The beach makes the place attractive to turtles. If you go to the next slide, you'll see that in relation to the proposal to expand the park, there are comments about the inadequacy of the marine park created in 1995. And you'll say, considering the law which created the park, there was no reference concerning the terrestrial portion that limits the marine area park and no mention of any special protection to the existing resources, making it important today to offer this project of law, which will enable the enlargement of the park limits and the necessary protection to the terrestrial ecosystems. And the next slide in our submission, and this has been cleaned up. We have it in Exhibit C-2F, I believe, but for the purposes of this, we've cleaned it up a little bit so you can see it clearly. But you'll see, and this is an attachment to a letter from the minister to the legislature, that the area we're speaking of has a 50-meter dimension and no more. And just we can slip through, the evidence deals with the need to protect the interior waters, and thus the going seaward had, in fact, a justification. There was a concern about protecting the turtles as they approach the beach. And you'll see this is the next one is simply a description of how that park law would in fact have operated. And you'll see that the 50 meters zone on this particular area demonstrates that the beach is available to the turtles, and there's in fact a berm, a natural berm behind the beach, which can be used to, if you will, govern responsible development. The next slide makes the same point in a different part, where you'll see the berm rises, and the turtles, of course, don't go into the forest to lay their eggs. They lay their eggs at the upper portions of the beaches. The next slide, simply with respect to the internal relations of the Costa Rican government, makes the point that, as a matter of just pure historical fact, the municipality was purporting to zone the land that is now said to have always been part of the park. The municipality didn't agree with that. They granted building permits. They purported to exercise zoning, and indeed one of the subsequent Constitutional Court decisions dealt with that conflict and resolved it in favor of the park. And that's ultimately, but at this time, my clients were not alone in thinking that development was possible, that you could obtain building permits from the local municipality, and you could carry out a responsible development, or a number of responsible developments. Now, the next slide deals in a very summary way, and I think we'll have to go in more detail in closing to this so that we carry our way through it. The title of this is a little bit misleading. There have been about 100 Constitutional Court decisions, by our count or more, which actually refer to the park. They're not all park boundary decisions, so the title's a little bit broader than it should be. And there were a number of proposed bills to change the park law. And these decisions, like the decisions often in many countries, don't all go one direction. There's a certain state of confusion created from reading these decisions, and I'll just touch on it lightly at this point. In 2005, there's a decision ordering Monet and Satana to consider establishing new guidelines for environmental assessments to be conducted as part of development. If you go to the next slide, you'll see that there's a resolution by Satana to suspend the processing of environmental permits within 75 meters of the public zone. And just to be clear, the suspension of environmental assessments is suspending the rights of the owners to establish that their development is consistent with environmental protection. So there's an irony here in the case, in that the actual means of freezing the claimant's properties was to disallow them the power and the ability to prove that their development would not interfere with the nesting of the turtles and was completely consistent with the goals of the park. Of course, to be blunt about it, if the park was to embrace and include their lands, and to be taken and expropriated and compensated for that purpose, then you could understand why the taking needed to proceed before they built their properties. But in plain terms, what the claimants were owed under the treaty obligations and under international law and under the Costa Rican domestic law was the honesty of the administration in saying, that's what we're going to do, and we're going to compensate it pursuant to the general law, the domestic law, and our international obligations. The next decision is there was a question about the court in that case refused to compel the ministry officials to consult with the cartographic service. IGN is the cartographic service of the government, as I understand it. And then we have the next important decision, which is in the spring of 2008, the Supreme Court of Costa Rica took the position that the 1995 law contained a typographical error and the boundaries were actually inland and not seaward. And we'll go into some greater detail of this in our closing, but you may recall from our pleadings that there was an opinion generated within the government that proposed that there was a typographical error. We say that opinion and this decision is irreconcilable with the materials I've already put to you. It's irreconcilable with history. That doesn't mean it isn't the general law of Costa Rica. As I said before, Supreme Courts are entitled to be wrong. That's in part why we appoint them. But what it does show as a demonstration of the history is that should not be visited on our clients by the respondent's position that they ought to have known all along that this fell within the park. It required not just foresight, but divine foresight to have reached that conclusion. So I think I can skip through the next couple of decisions, but I would say this, and that is there was, maybe I shouldn't, if you go back to May, I'm just mindful of the time, this is not unimportant, which is that there was a decision in spring of 2008 in which the court appeared to have actually ordered either the immediate expropriation or the development of guidelines. And then, in December of 2008, the ministry was ordered to expropriate all private property within the park immediately. You would have thought that was the end of matters. It was actually more in media res, I think would be the Latin expression, more in the middle of matters. If you then go, you'll see that in response to a further request, the court in the spring of 2009 actually said that it was up to the administration to decide what to expropriate and when, and that their earlier decree to do so immediately was not intended to introduce the court into the administration of the government. And the next slide, which is an extract from that, you'll see that it says that it's not their place to indicate when to expropriate nor how to go about it, as that is the responsibility of the respondent administration. So the earlier judgment, which contemplated an immediate action, was mitigated by that reference. I think that slide's reference to a resolution is wrong. I'll double check that, but I think that, I believe, is an extract of the judgment itself and the English translation for it. The next important stage in the facts, and we'll probably finish this and then take the morning break, but is what then flowed from that, of course, as I said earlier as part of my opening, was the unhappy, if you will, and unwanted obligation to pay for the very valuable lands, which by reason of this conclusion of typographical error, the state now had a responsibility to buy. It had that responsibility under its own law. It had that responsibility under international law. Of course, we have CAFTA coming into effect, in which they've promised to citizens of the CAFTA treaty that they will honor those obligations. And what you have within the administration is this Contraloria report, which effectively we now know has essentially been responsible for, or at least action based on it, has been responsible for the indefinite suspension. And I say indefinite in that we're still in suspended mode today of the expropriation process. On my reading last night, my understanding is that the position of the respondent is that all the conditions of that report have not yet been fulfilled. No time for the end of that process has been offered to the tribunal. Essentially all of the various procedures which under domestic law might offer some compensation to our client, for the most part, have essentially been suspended and have taken no further steps. And if you look at the Appendix 2, at this point that might be a good thing. And if my notes to my own document are correct, what I draw your attention to essentially is if you look at the Ventana slots at the top, which had essentially proceeded to the administrative assessment stage, and those are the ones going down, starting at the top, going down to sort of the white blanket at Ventanas. All of those have been essentially suspended since 2010, if I'm right. And then just while we're on there, you'll see that there have been essentially 3 titles transferred of all of the titles in issue throughout the history. Now, there are a number of failed efforts to resolve these problems both before and after the Costa Rican Supreme Court's decision. And the next slide summarizes some of those. And these are all genuine efforts. So in 2002, there was an effort to expand and consolidate the park, which failed. I referred to you earlier to the goal to actually expand the park, to make it clear. And that would, of course, make it clear, but that failed. In 2006, there was a bill that was I understand, advanced that would interpret seaward as inland before the Costa Rican decision, and that bill failed. In January of 2008, there was a bill to interpret seaward as seaward, and that bill failed. And then finally in 2009, there was an effort to reconcile the development adjacent to the park and to have a mixed refuge, and that lapsed and was essentially archived in 2013. I think the slide says achieved, and it wasn't achieved in 2013, it was archived in 2013. There's a procedure, as I understand it, within the administration where if a bill's not been acted on within a certain period of time, it lapses and is then archived. So that should read archived. So, and the next slide deals, as you'll recall, the claimant's position in this proceeding is that they had a reasonable and detrimental reliance on the assurances that these properties would be available for responsible development. This is actually, the slide needs to be corrected because it should read minutes after meeting with Brett Kirkowitz. It's not the meetings of his meeting. And just to, in dealing with the fact, the respondents we have a meeting with Mr. Berkowitz and the minister, which is contested on the record. And Mr. Berkowitz.
May I just ask which slide we're on? The one that I'm seeing on the screen seems to be different from the one that we've got in the binder.
Continuation.
It's the continuation.
I think so.
Is it that one?
So your slide should say position on development.
I was just looking for the one that said, if you go back to the previous one, the agenda of the meeting included the following. That's that we don't have, or it's been cut off in the packs, it looks like. Anyway, I mean,
the one on my screen says position on development.
It looks as if it may just have printed incorrectly. You can have a look at that afterwards, but just to draw your attention to it, it's that slide. It's just has not come.
You may have the right slide, and the one on the screen is the wrong slide. Let me just see. No, that's the. I think that's the right slide. But
yes, it's just rather different from what you've got on the screen. But no matter, we can come. I don't want to delay you. We can come back. To that.
I see. I'm sorry. Yes. Okay. So. I'll just keep plowing on, but the mistake I'm drawing your attention to is within the box, you should strike minutes from meeting. Yes. That's not correct. But just from a council's point of view, what I'm drawing to your attention, Mr. President, is this. There is a controversy on the witness statements about the content of the meeting. There's no doubt there was a meeting. We don't have a statement from the minister. We have a statement from Mr. Berkowitz. But from what I commend to you, and I will return to this, of course, in closing, is that his evidence that he was reassured of the position of the government and that that was given to him before he had made his final payments to purchase this property, is completely consistent with this document, which is made a few weeks later, and he says was referred to not explicitly in the sense of it wasn't available to him at the time, but the fact that there would be a statement of position rendered is consistent with it. So for the purposes of deciding as a matter of fact whether or not those statements were made, I say that this provides substantial corroboration of that fact. And you'll see if you go, hopefully, do you have a slide which says it is important to point out?
Yes.
Okay.
It's rather different from the one that you're on the screen, because at least in our packs or in mine, it comes halfway down the page, but I think we've got the text in front of us.
Okay, so just for the purpose, and this, we have, of course, the whole document in the record, but the points of this for the purposes of opening I wanted to point out to you is that the statement here is that the ministry did not encourage the expansion of the park, which was a proposal being advanced, that the park would not be expanded to any area that was declared an area of tourism interest, and that in the private area, the ministry wanted to promote a voluntary conservation regime instead of expropriations. I'm sorry, the exhibit C53, if you want to make a note just so that you have the right reference there. And you'll see the next slide is any development shall meet the criteria that shall be defined as low density, proper use and management of lighting, green curtain use and implementation, among others. That's a summary of what I've been calling responsible development. Now, I think I can move through a number of slides quickly before the break. The next slide's not really controversial. Of course, you need to, in order to get a building permit in this context, need a number of things, including an environmental impact assessment. That's the critical matter that was halted. And then there's a number of slides here just to illustrate to you or show you dramatically that if you had gone to the land registry and seen things, what would you have seen at the time? Well, here is what was on the land registry drawings for these lots. And the English says in conformance with Article 47, this office does not object to the plan as it is outside the national park. And the next slide with respect to these Ventanas lots says it is outside the national park. The next slide, which is fee 59, is interesting because it refers to the 91 law. It says it's in the park according to the 91 law, and you'll recall the changes to the boundaries of the park in the 95 law. And the next slide says that this is outside the park. The next slide says C96 is outside the park. And then you'll see with respect to South Playa Grande 1 and 2, and you may want to make a note that I think it says 20% approximately is in the park according to the 1991 decree. This is an example of a reference to the decree and part of SPG 1 and SPG 2 being within the park. With respect to the B lots, you'll see it says approximately 40% as I read it in the park according to the 91 decree. That law says 91 law, it should say decree, just to be clear. Now, Mr. President, I think that's my note is that I was to stop about now for coffee break, and I'm on time. I have a lot of slides to go, but the next 30 or 40 will take very little time. They're sort of by way of a timeline demonstration, so I'd suggest if we could that we take the coffee break now.
Thank you. Let's do that. Do we have a... Why don't we come back just after 5:02?
Thank you.